All right, so good afternoon, everyone. This is the event on what can constitutional law do for its own success, a comparative experience on securing rule of law and democracy in new constitutions. This event is organized in the framework of the Catholic University of Chile and its Foro Constitucional, and also our sponsor is the ICON's new chapter on Chile. Right now, I would like to give, first of all, the word to our Dean, Professor Gabriel Boxang.
Thank you very much, Professor Fröhlich. I would like very simply to welcome you to this very important event that we're having today. I would especially like to welcome Professor Tom Ginsberg from the University of Chicago, Professor Andras Jakob of the University of Salzburg, and Professor Mila Versteeg from the University of Virginia. It's a wonderful moment for thinking, for trying to explore all the possibilities and all the impact of this important constitutional moment in Chile, and to do it with a comparative perspective with such important specialists is really a privilege. So it's a great honor to be sharing with you this transmission, and welcome to the Pontifical Catholic University of Chile. I would like also to thank our professors Johanna Fröhlich and Patricio Zapata, who are moderating and also explaining a bit how it will work today, so you can participate in this transmission with your questions from your homes. And of course, I would like to thank ICONS Chile that is bringing our support, their very important support to this activity. Finally, we are very, very grateful to the Foro Constitucional. So Professor Alejandro Valle is here, and it is one of our important activities and important projects that we are bringing as the Faculty of Law of the Catholic University of Chile to promote truly academic reflection on what Chile is living during these days of important constitutional thought in our country. So thank you very much to you who are participating in this event, and of course to everyone who is following us from their homes. So thank you very much, and God bless you.
Thank you very much, Dean and Professor Boxang. Now I would like to give the word to a short greeting to our Spanish public, to our professor and co-moderator of the event, Professor Patricio Zapata. The sound has to be turned on.
Yes, it has to be turned on. Hola, muy buenas tardes acá en Santiago de Chile. Buenos días en California. Es un agrado para el Foro Constitucional de la Pontificia Universidad Católica realizar este seminario. What can constitutional law do for its own success? ¿Qué puede hacer el derecho constitucional para su propio éxito? Big question, gran pregunta, y tremendos invitados a quienes saludamos y agradecemos su presencia. The conversation will be held in English, pero habrá una traducción de algunas partes en el chat, de manera que nuestro público chileno y chilena que quiera podrá en el chat encontrar algunos resúmenes. No es traducción simultánea, pero algunos resúmenes. Sin mayor preámbulo y agradeciendo especialmente a Alejandro Valle, directora del Foro Constitucional, a nuestro decano, Gabriel Boxang, dejo con ustedes a la verdadera protagonista de este evento en términos de organización y de preparación, nuestra querida profesora Johanna Fröhlich.
Muchas gracias. Thank you very much, Patricio. So now I would like to introduce our speakers today. First of all, Mila Versteeg, she's a professor of law of the University of Virginia School of Law, director of human rights, the Human Rights Program, and director of the Center for International and Comparative Law. Her new book on how constitutional rights matter, co-authored with Adam Chilton, was published by Oxford University Press last year. Our other speaker is András Jakab, a Hungarian professor of Austrian constitutional law and administrative law from the University of Salzburg. His newest book on the European constitutional language by Cambridge University Press was published in 2017, and he has been publishing various articles with the titles "How to Save," "What to Do," in situations of democratic erosion. And our third panelist speaker is Tom Ginsberg, professor of international law, research scholar, and professor of political science at the University of Chicago Law School. His latest book on how to save a constitutional democracy, co-authored with Aziz Haq, was published by the University of Chicago Press in 2018. So as you can see, we have three marvelous speakers, professors, academics, and researchers with us today. All of us who have, all of them have this approach, this practical approach of how to fix, what is that, why something matters, like in the case of Professor Tom Ginsberg, about why constitutional amendment rules matters, in what sense does it matter. So actually the event structure and background thought or vision is also related to these practical questions about rule of law and democracy, concretely related to the Chilean context. And our first question regards the procedure, the constitutional making procedure in Chile, and is the following. So under these circumstances that we can find ourselves in, of social unrest and a divided constitutional assembly with several independent members and no single political force with a major political influence, now that we are after the elections for the Convención Constitucional, what are the tools of constitutional law to foster compromise and consensus? So what can constitutional law really do in order to foster agreement in such a situation of divided political forces? And first, I would like to give the word to Professor András Jakab.
Thank you very much, and thank you very much for the invitation. It's an honor for me to be here. I actually prepared a few slides just for the first question. I promise for the other questions I haven't prepared anything longer, but for this intervention I do have a few slides which I'm trying to show to you. I hope that you can see the slides. Can you see the slides? Hello?
Yes.
Can you see?
Yes,
Good.
yes.
Okay. Sorry. So it's just about the generic question: what can constitutional law do for its own success? So, just a few remarks at the beginning, because I have seen a few constitution making processes, and I have also did some research on constitution making processes, and as far as I can see, there is usually, I mean, I don't know much about the situation in Chile, but usually there is a lot of naivete in moments of constitution making. Very often constitution making is seen as some kind of miracle where you can solve all your social problems in a society. And my first warning would be that you should definitely not consider a new constitution as something that would solve the actual social problems. As a matter of fact, most or almost all constitutional changes can be achieved through amendment. So just changing one by one the various provisions in a constitution. And if you adopt a new constitution, that's more of a symbolic act, which can have political relevance, or if you want to show that you finished with your past, or you want to, like in the sense of transitional justice, you want to show that the past was sinful or wrong, then it can be useful. But for changing the actual factual or normative situation, it's normally it's not a key, the act of constitution giving. Most social problems require concrete policies, which then need to be implemented in statutes, so not on a constitutional level. And my understanding, especially when I look at Eastern Europe, where you have lately lots of problems with rule of law backsliding, is that these can be traced back to cultural issues. And my hunch tells me that also in Latin America, you might have a similar problem. So the first task is, I think, always to establish what the social challenges are. And when I read this Acuerdo por la Paz Social y la Nueva Constitución, and my understanding is that the major social challenge that is explicitly mentioned also in this document is paz y justicia social, so basically peace and social justice, which I translate for myself as inequality and polarization as key two issues that can be seen in Chile. And once you establish the challenges, then I think the next step is always to identify what cultural factors can be blamed for these, like lack of compromise or acceptance of corruption in a society. And then only the third step, you should think about what legal, constitutional, statutory rules are needed. And when you think about what rules you need, you should always try to see it as a package. So not just the rules, which are more like these formal institutional elements, but also the informal, so cultural or behavioral elements in a society. So the task is not just making new rules, but the task is always institution building, especially because formal, in my understanding, but maybe Mila or Tom will disagree, but my understanding, formal and informal elements can substitute each other to a limited extent. So you can have technically, how to put it, not too developed constitutions. The US Constitution with today's standards is not a good constitution, or in the UK, where you don't really have a formal constitution, but you do have formal rules, is also very patchy. But there are informal elements which can still make it work. And you can also have excellent constitutions. One of the best constitutions is the Constitution of South Sudan nowadays, and the results are disastrous because of informal elements. You should also consider that new institutions always remain fragile when you try to build them until they become habitual. So they just need a long time, and very often external help can be useful. I mean, in Europe, certain institutions of European integration, or possibly the Inter-American Court of Human Rights, so possibly references to that, or references to the case law of that court might be a helpful factor of stabilization. I think you should consider constitution making, or in general, like making legal rules in the context of transformative constitutionalism. So in the long run, cultural traits can also change, but not in the short run. So smart formal rules can be useful for that, but they, on their own, they cannot solve the problems, and it takes time. So it is not a hopeless, but it's a very difficult task, and I call it, or other people call it, institutional alcoholism. So they always try to build democracy and rule of law, and it crashes. And there are quite a few countries in Latin America and also in Eastern Europe where you can see that this backsliding dynamics. So what to do in divided societies? That was one of the specific questions. What I think doesn't work, even though often they try to use it, is various rotation systems and quotas. They can be helpful when, right after a civil war, they can help to stabilize the situation, but in the long run, they are usually counterproductive. because they entrench legally the division in the society. And we can see examples how it can go wrong in Cyprus or in the constitution, in the former constitution of Serbia and Montenegro, which doesn't even exist nowadays, or in the constitution of Bosnia and Herzegovina. They all basically entrench the divisions, ethnic or whatever divisions in societies. So I think if you wanna fight divisions in society, if you want to counter it, then much more useful are smart voting systems with preferential or negative voting systems, where either you can rank the parties or you can also vote against the party, because these voting systems disfavor divisive politicians. And possibly you should also consider to legally introduce such voting systems, not just for I don't know, parliamentary votings, but also by statute for internal votings within political parties, because mostly when you have breakdowns of democracy, the whole problem begins already at the level of political parties, and then it grows big. So basically, you need legal rules which make it worse for self-interested politicians to act for the common good, because you can write in a constitution what would be ideal, but it's more about the mechanism which motivates them. And the final question, which was also asked specifically in the question, is what to do in divided constitutional assembly. So some tricks which I have read about, or how it was dealt in other constitution making situations. So if you cannot agree, then you have various ways to find a solution. One is to use vague concepts. By using vague concepts, you delegate the decision to courts, and especially in divisive moral issues like I don't know, abortion or euthanasia, it's kind of advised not to have an explicit concrete solution in the constitution, because a large part of society will necessarily disagree with it, and you don't want to take it on, because that will hamper the possibility for a constitution to be a common ground for the political process. So delegate it to the courts by using vague concepts. Or you can also explicitly delegate it to later legislation. So if you cannot agree on something, then you can just say in a certain statute, maybe in a statute with qualified majority, the issue will be regulated later, and that's also a way not to put too much weight, or not to put these problems, or not to bring them into the text of the constitution. Possibly you can mention certain factors that might be relevant, but maybe not even that. Or just remain fully silent on the issue. If you cannot agree on it, then just don't mention it in the constitutional text, which either means that somehow courts will decide it, or the legislation. Don't even specify that. So just don't try to solve all the social problems suddenly in the constitution making process, because it's not going to work. And in doubt, just keep the status quo. I mean, that was a pretty successful solution in the Austrian constitutional making in 1920, where they couldn't agree on the catalogue of fundamental rights. And basically what they did, they just said that we're going to use the old catalogue of fundamental rights from the imperial time. And it did work quite a long time. So you should consider the constitution only as a common minimum. And if you cannot agree in certain things.
The sound went off, yeah.
So that's it. And I mean, basically, I wrote more in detail about these issues in a few papers, and I'm happy to answer now or anytime later if you write me an email. So thank you again. I hope I wasn't too long.
Thank you very much, András. It was great. I will not occupy more time and give the word to Professor Tom Ginsburg.
Thank you very much. And András has given a very good overview of the internal resources available to constitutional law. But he also made an important point, which is that the situation facing Chile cannot be resolved from within law, right? That, you know, obviously cultural, political, social dynamics are going to determine what happens now. So what I would like to do is just say a word about Chile specifically and the Convención and where we find ourselves at this moment in light of the question. So one important point, obviously, is that, in the way that the election came down, the citizens of Chile, didn't give any force a veto. So that's actually really good in the present moment. Before the convention, I was very worried about this 2/3 threshold that is required for every norm to be changed. And there's still some questions about how that will be implemented. We'll learn when the rules are adopted. But given that this election result didn't give any force 1/3 veto power, now I think the 2/3 threshold is probably good in terms of generating consensus, which was Johanna's question to us, because obviously you need supermajority. One of the odd things, though, about Chile's politics is that the public, elected all of these independents at the same time they were in the same election electing politicians, traditional parties for the mayors and things like this. So it's a very interesting moment, and perhaps one of the few cases that I can think of in which the constitutional politics are taking place at the same time as the ordinary politics, and yet with different players. I think that's very interesting, that this constitutional convention really is very different. And, even though I've always been skeptical of the idea that constitutional politics are different, maybe this case they are. That means that whether or not we get consensus probably doesn't depend on law. It's going to depend on the behavior of these independents who have the overwhelming majority of the Constitutional Convention. It's just an interesting situation. And for that, whether they achieve consensus is partly going to be a matter of law in the sense of the procedures, the rules of procedure. And so once we know about those, we will have an idea about the prospects. But, whenever you have a bunch of independents making decisions, there's the problem is, of course, that they, are hard to gather because they don't have parties. And also they have no experience in many cases. And there's a third challenge which we face right now, which is the culture. It's found in Chile, but it's found in many countries. The culture against law and against, maybe not against law, that's too strong, but against traditional political forces. We want new politics, so everything has to be out in the open. And, no secrecy, no backroom deals, no parties. That sounds really good in theory, but of course, you can't actually adopt a constitution unless there's some negotiations and things that occur in some room somewhere or some telephone call. So I feel like the public has a kind of unrealistic expectation about how you actually create new constitutions and create legal change. And there's some risk that there might be too much transparency. That's what I think is the risk. I know it's not a popular position, but I think it's a real risk in Chile right now. If you get a bunch of inexperienced people and they think that every conversation has to be in the open, it's very hard to come to agreement. So in that sense, that is the solution is a kind of legal one. It's about the rules of procedure and making sure that transparency is there, but not making what we'd say a fetish out of transparency, not making it too much transparency. So I think that's going to be a critical decision, and it will determine the success or the failure. The other legal point I would make about Chile is that, when the social explosion happened in 2019, there was the decision to create the convention as a constituted power, not a constituent body. And we all know what happened when you had, let me say, of course, in the United States, our Constitution was created by a constituted body that turned itself into a constituent body. Our founding fathers were given a job of just doing a few amendments, and then they just said, no, we're going to write a whole new Constitution. So can the channels of legality hold? Will the convention maintain the legal continuity with the past regime? And I think so far, from my reading, the answer is yes. there will be legal continuity in Chile, and there's not a risk of, taking over the whole system or something like that. So I think that's interesting and important, and does again go to the question about what can law do. In this context, I think continuity of legality is really important because it keeps some boundaries on the process, and especially in a very polarized situation, helps convince the potential losers that there's going to be limits on how much they lose. So I think that's probably all I have to say to this question.
That was great, really. Thank you very much. I will give the word to Professor Mila Feste. Mila, por favor.
Hello, first of all, thank you so much for having me here. And I'm grateful to be here and to be learning about this incredible constitution-making experience. So I guess I want to maybe take a step back again and talk a little bit more about this at the theoretical level, but I'll be brief. And I guess I partly want to respond to Professor Jakob, who said something which I think is important, but I'm going to disagree with. He said, everything can be done by amendment, right? Whatever you want to accomplish as a matter of outcomes in constitutional law, you can do it by amendment. So you don't really need to write a brand new constitution, right? And that's technically true, but I think there is something important. There is a really important difference, which is in the process, right? As Professor Ginsberg touched upon. So when you call a new constitutional assembly, these processes tend to be more inclusive and they tend to be more transparent, or maybe not transparent, but in this case, they're going to be likely be transparent. And I think that is going to affect outcomes in important ways, in the sense that constitutions that are written that way are likely going to be more legitimate, right? People feel like they were part of this conversation somehow, and that may matter. So there is some research that shows that more inclusive constitution-making processes actually are associated with democracy, better democratic outcomes in the long run. This is research by Professor Eisenstadt and his co-authors, no matter what you end up putting in the document, right? So there is this view out there that, right, all this technical stuff, what works and what constitutional law can really do for its own success, it may matter, it may not matter, but how the Constitution is written matters a lot, right? I mean, this is partly an empirical question, but I think there's some evidence to suggest that how a Constitution is written does matter, and that it is important to have inclusive processes, that a 2/3 decision-making rule is probably a good thing, even though it's hard to get consensus and it may lead to ambiguities in the Constitution or some bad drafting decisions. But in any case, there is, if it's a document that is a result of that kind of process, that may actually matter. It may matter for legitimacy, it may matter for democracy in the long run. I also believe it matters for its enforcement, right? I personally believe for constitutions to become real, it requires people to get upset when a government violates the Constitution, right? It requires people to wave the document at the government and say, hey, my rights or some other constitutional rule are violated. And for that to be the case, people need to care about the document. It needs to become alive and become part of the broader culture. I always think, I'm not an American, but I live in America, and I think one of the most amazing things about the US Constitution is that ordinary people know it, or they think they know it. And I think that's possibly important. So I do believe that there is a difference between how you get there, even if the result is the same. And maybe even to go a step further, some of the questions on like what rules really work for constitution success, right? The overarching question that motivates this panel. I mean, those are empirical questions. And I in my own research, I mostly do empirical research. And I can tell you it's really hard to establish what actually works and what doesn't as a matter of constitutional design. For example, I just recently did some research, which I know is a debate in Chile, right? If you put social rights like the right to healthcare or right to education in the Constitution, does that cost a lot of money for the government? Turns out if you run correlations across country between rights, social rights and constitutions and government spending, there is no relationship whatsoever in the global data. Right. So one conclusion is like they don't work. But then if you start digging deeper, they work in some countries, but then not in others. Right. So it may be countries where there's also social movements and strong courts. So everything is kind of contingent in terms of what works and what doesn't. So I think we should be careful just making general statements about what works for constitution and what doesn't. A lot of it is going to depend on the context. And experts should be cautious when they take up these questions. Okay, I'll leave it at that. I'd love to continue the conversation later.
Excellent. That was great. I think now it's Professor Zapata's turn to make the next question.
Yes. So we turn on to question number 2. And it has to do with the tension between rule of law concerns and the deepening and strengthening of democracy. There's always been a tension between rule of law and democracy, and we don't want to talk about that in abstract. We want to talk about South America and Chile. And the question would be, in which ways could this process, this democratic process, could consider and respect the limits? Tom Ginsberg talked about continuity, and he said, can the channels of legality hold? Well, we want to go further on that questions. How could constitutional law help? Rules help, courts help in making that possible. So the channels of legality do hold, if that's something we think it's important and valuable. And in this case, we will start with, this was agreed upon, so I'm not doing anything arbitrary. We will start with Professor Ginsberg, and then with Mila Versteeg, and finally with Andras Jaikov. So Professor Ginsberg, you have the floor.
You know, it's a great and tough question. I'm going to be very brief because I think I probably have more to learn from my co-panelists on it. You know, these days, one of the global developments is the doctrine of unconstitutional constitutional amendments, where courts put themselves in the position of saying what is and what is not constitutional under the framework of the rule of law. And obviously, this is an example of that deep point that there's a tension sometimes between rule of law and democracy, what the majority demands. I think it's a real challenge in this particular context of Chile. And basically, as long as the politics are working, the courts should somewhat stay out of the way, because you do have this specially elected body that has higher legitimacy. You know, there's, as I understand, not justiciable, the things are not justiciable before the Tribunal Constitucional, and that seems appropriate given the perception of that body in Chile. So, you know, I guess what I would say is, in this particular context, to me, the most important thing is, you know, legal continuity, and then sort of principles of the rule of law. That is, sort of principles of legality and, you know, accountability and publicity, you know, at a fairly abstract level. But I don't see much role in Chile for courts getting involved, because that would mean that the bargaining has totally failed in some sense. So I hope that the courts just stay out of the way, and that the internalization of rule of law values is what is driving the process. And I understand, someone told me that a majority, or a lot of, maybe not a majority, but a lot of the members of the convention are lawyers. So that's another channel by which legality can sort of be a check. Thank you.
Thank you very much. Mila?
Yeah, so I'm not sure I have a great answer to this question, and there's so many potential parts to it, but one way of understanding it, right, is this constituent assembly bound by law, or is it higher than law, and is it not bound by anything and can basically do whatever it wants, even if some of those outcomes contradict our understanding of what the Constitution should be doing, right? So for example, one area where this comes out is the relationship with international law and the existing legal commitments of Chile under international law, right? Could they potentially be disregarded or ignored? I think that is a really hard question to solve. I mean, I think most people agree that some of international law consists of higher norms that ought to be respected, especially in the area of international human rights law, for example. But I think these are sort of the hard questions that I don't have great answers to. I was maybe going to say something also to to the broader point of the relationship between constitutions and rule of law, which as a theoretical matter, I certainly don't have time to go into, but I was reminded when you sent me the question of a little something that Tom probably forgot, but Tom and I some while ago looked into some of the empirical relationships between constitutions and rule of law and whether and how they are related. So I thought I may be interested to mention some of that. So first of all, we found a lot of constitutions say, oh, rule of law is important. And we found that the constitutions that say that are actually less likely to respect the rule of law. So we found there was a negative correlation between mentioning the rule of law and actual rule of law. And then second, we found also, I think, interesting in this context that the more rights you write in a constitution, the less the respect for the rule of law was, or less there was lower, was associated with, and these are merely correlations, right? I'm not claiming a causal relationship, but was associated with lower respects for the rule of law in general. And of course, there's a question, how do you measure rule of law? I'm happy to talk about it. It's a whole big topic in and of itself. But it is fascinating because, and I can talk about this a little bit more when we come specifically to the topic of rights. But time and again, if you look around the world, there's a type of constitution that basically every good value that you can think of becomes a right. And one way of putting that is if everything becomes higher law. So one way of thinking about if everything is higher law, then arguably you don't really have a higher law anymore. It is a concern there, right? Because you elevated pretty much everything, so everything becomes open to ordinary politics again. So there is some concern that making everything a right is not actually conducive to rights. It's actually the correlation. If you look at the data, you also find that those kind of constitutions are associated with lower respect for rights in practice and lower levels of rule of law. So that was another thing we found. And then by contrast, we found that constitutions that weren't replaced very often were associated with higher levels of rule of law. So stable constitutional systems that don't rewrite their constitution from scratch very often were associated with, again, correlation, not causation, with better, higher respect for rule of law. And then we found that constitutions that actually don't try to do too much, so just cover fewer topics overall, were also associated with higher levels of rule of law. I mean, I thought it would be interesting for our conversation to put some of these empirical relationships on the table, the bigger question of, how are we going to define rule of law and how do we define constitutionalism and how are they different or not? I like that. Then we need another 5 hours at minimum. So, but I thought I'll put that on the table.
Thank you very much, Mila. Very enlightening your reference to correlations and data and so on. So thank you very much. Andras, please.
Just a few words. It was also mentioned in the question, and I think also Mila mentioned it as is, we cannot really discuss here the concept of democracy and the rule of law. It would be like a much longer event and probably like a hopeless task. But also what was mentioned in the question, how we define these generic concepts, that always depends also on certain political preferences. So they seem like neutral, generic constitutional concepts, but as a matter of fact, their definition depends to a certain extent always on what we want to achieve with it. And in a pejorative way, you can say, that's like arbitrary, or it can lead to conceptual overreach. I think you even mentioned it in the question, Johanna. But I think that's in the nature of doctrinal reasoning. So basically, you have certain concepts, like here, key concepts like democracy or the rule of law, and as a lawyer, you try to redefine them, you try to occupy them according to your own preferences. So you can define the rule of law more as a formal rule of law, or you can also include in the rule of law substantive elements like protection of fundamental rights, or also certain minimum levels of justice, again, depending on how far you want to change the status quo in a country. I don't think that that can be understood independently from these ambitions. And maybe just a second remark, just to keep it short, is that it's very difficult to say, or very difficult to establish, whether what you have in a constitution, or even the process that was mentioned before that, how far it is, causing something that's later happening, or how far what you have in a constitution is just a symptom of certain cultural traits in a society. So you can say that, I think that was also mentioned by Mila, who just probably would like to point out that the fact that you have something in the constitution, and then, for example, you have a good, high quality of the rule of law, it's extremely difficult to establish whether that high quality of the rule of law was caused by what you wrote into the constitution, or whether you have certain, cultural traits in a society which lead to higher quality of rule of law, and which also lead to the fact that people happen to mention something in the constitution. Also, maybe you have in a society very consensual or compromise, or a political culture which is open to compromises, and that leads to a certain constitution making process, and that leads to also, like for the, more successful constitution. So it's difficult to establish, but it's a fascinating topic. So I don't think we're gonna solve it, but these are, very valid questions that were also asked by Mila, and I think we're gonna discuss that also later. So that's all.
Thank you very much. Yes, there are. We can see that parts of previous question, and especially future questions, are already appearing in the answers. And now the next question actually relates a lot to what you have been talking about, and especially a concrete comment by Professor Ginsberg. And is about the abusive practices of constitutional law, or maybe better to put it better, the abusive practices of adopting, amending, changing constitutions that have, as we have seen in various forms, we have seen happening in various different ways, but also we can maybe note that there is a common logic of power that is in the background, perhaps. And so also throughout the constitutional making procedure here now in Chile, actually the Superimport had to already face a certain issue with with the amendment of transitory provisions that was about a very concrete issue that is happening in Chile here. But there the unamendability of certain parts of the constitution already emerged. And so the next question relates to this, and is the following: is there any kind of built-in defense mechanism that constitutional law as such, as a discipline, has developed to fight its own abuse, and how can actually constitutional law affect its own change? And maybe we can add affect efficiently. Anyway, we can start now with Professor Andreas Jakob. Please, the floor is yours.
Well, okay, thank you. I haven't prepared much to this question, so it's about multi-layered constitutions, and just two examples of what ways I can see about multi-layered constitutions. One is the German example, where you have eternity clauses. So, I mean, this is one thing that you cannot achieve with amendments once you have an eternity clause. Then, and if you want to change that, then you actually do need a new constitution. So I have to correct myself, my first comment. So this is definitely something that cannot be achieved by amendments. But what we have seen in Germany in the last decades is that eternity clauses give enormous power to constitutional courts or Supreme Courts. And in general, as a constitutional lawyer, you always like to see certain limits for any constitutional organ. And then in Germany, there is a huge debate about how far the German Federal Constitutional Court is actually abusing its position, especially concerning European integration, like basically hampering European integration by very creatively deducing from the eternity clauses certain limits of the European integration. Whether you want to have such a court in a legal system, that is, to my view, questionable. I think a better way is the Austrian way. I mean, not because I'm sitting in Austria, but I think it's a smarter way of handling the position. I think it's a good idea to have multi-layered constitutions. I think it's a good idea to entrench certain basic principles, but I don't think that eternity clause is the right solution to that. I think it's much better if for certain basic principles you have an even higher procedural requirement for the change. I mean, in Austria, it's referendum, so you need the normal constitution-making procedure. And if it's about changing basic principles, then you also need a successful referendum. But there are other countries where you have other solutions, where you need like a special convention, or where you need even higher percentage in the parliament, or other requirements. I think they are all possible solutions, but I would be cautious about eternity clauses as a solution for multi-layered constitutions. So that's it. It's very short. Thank you.
Thank you very much. Yes, so I would like to give the word to Tom Ginsberg, Professor Tom Ginsberg.
Great. Yes, I think a lot about this. My last book with Professor Huck is really about this question. You know, what are the internal resources of constitutional law to prevent backsliding? And it's a very important question in the United States, because we have both we had a president, but also, more importantly, a party that seems, a major political party that seems to be giving up on democracy in many ways. There are many signs of that. So what can we do, and what resources would I like to have? And the fact is, we don't have enough resources in the United States in our constitutional law, but it does inform the answer. One thing I would like to see is constitutionally protected independent electoral administration. Most countries have this. It's very obvious. We don't have it. Constitutionally protected right to vote. We don't have that either. There's no right to vote in a general sense in the US Constitution. And that's a kind of obvious thing. And then maybe just to say one other, because the book has a lot of them, but one other thing I think would be good that I like is for amendment rules. I really like the design that they use in Scandinavia, where you have a amendment proposal, and then it's adopted after an interim election. You know, that the parliament that is making the amendment is not the one that proposed it. And the reason I like that is because most amendments in most constitutions are technical and small and not very important, and they will just sail through. But if you get something like the Hungary situation, which Andras obviously knows much better than me, where you have a temporary majority or a one-time majority, they can't lock in the constitution. They can't change the whole constitution just because they won one election. And it gives the opposition a chance to mobilize against them. So I like that idea, temporally extended constitutional amendment processes. There are many other ideas, but I'll stop there.
What a pity that you just stopped, but I hope that we are going to hear more. It was very, very interesting. So now I would like to give the word to Mila, Professor Festey.
Yeah, hi. Okay, so the question, what can a constitution do to prevent undemocratic practices, right, is the broadest way to frame the question, is obviously very broad and very important. I mean, there's some standard answers in the literature, some of which have been given by my colleagues, right? So part of the answer is in amendment rules, so different amendment rules. And then we have the eternity clauses that Andras talked about. So some parts are unamendable. You can make some parts harder to amend. So that's tiered amendment. There's other variations on that Tom was talking about. Another thing worth mentioning is you can also just write in the Constitution how it ought to be replaced, right? So one obvious loophole, if it's hard to amend or some parts of the Constitution are unamendable, is to call a new constitutional assembly, because then you're starting over again, right? So sometimes the prior Constitution can actually govern the making of the new Constitution, or that's the idea. Then some other standard answers are really rooted in this idea of militant democracy, right? Sometimes democracy needs to be somewhat undemocratic to protect democracy. So the practice of banning certain parties that have undemocratic agendas is something that's sometimes mentioned. The idea that some type of speech is not protected if it's undemocratic in nature, right? So we don't want certain ideas to get out there in the marketplace of ideas in the first place, which is very different from in the US, where there is this commitment to the marketplace of ideas, and this idea that every type of speech is protected no matter what it is, because then ultimately in the marketplace of ideas, the truth will come out or something like that, right? So those are some of the standard answers in the literature. There's many more specific recommendations, and obviously Professor Ginsberg's book is tremendously important. I do have to say though, as an empiricist, a lot of these are intuitions. We don't really have good data on what actually helps us prevent democratic backsliding. And here I come again to my point, like some of these things seem to work in some contexts, but not in others, right? Everybody loves to point at the Colombian Constitutional Court, who prevented the highly popular president Uribe from amending the Constitution to allow himself to run for a third term, right? The Constitutional Court said that's basically an unconstitutional constitutional amendment. If you want to remove term limits, then you would have to call a constitutional assembly. That doing so was hard. President Uribe left office, right? This is like the great success story, constitutions saving democracy, except it happens only once ever in Colombia, right? So I think it's hard to know whether that can be emulated elsewhere. And if anything, we see term limit amendments are passed all the time. In fact, it's the most frequently amended provisions in constitution, period. Presidents like their jobs. They usually love to stay in office longer than they're supposed to. So in any case, so I think it's hard to give a consistent answer of what actually worked, right? And I guess I want to maybe go back to our first point of discussion. I personally think, but this is also an intuition, I don't have data, that the process by which a constitution is written may also matter in terms of protecting undemocratic against undemocratic future practices, right? If you can actually write a constitution that in which many groups see themselves represented, it is less likely that they will then in the future go and seek to undermine the document. So I think maybe the process by which a constitution is written matters as well. Okay, I leave it at that.
Thank you very much. And just before we go to the next round of questions, I would like to remind our public that we are publishing little summaries about the conversation. Solo me gustaría recordar a nuestro público que estamos publicando resúmenes cortos en la función chat para que puedan seguir nuestra conversación. Y también vamos a publicar una transcripción de la conversación, lo que vamos a publicar en la página del Foro Constitucional. Sorry for this little intermission, and now I would like to give the word to Professor Zapata.
Thank you, Joanna. Most of you know that the Constitutional Convention has some borders or limits that were written on the Constitution, explicit limits. The formal ones that have to do with the quora or quorum to be acquired to get a new norm in the Constitution, in the project, the 2/3 clause. And the tuition over that rule was given to the Supreme Court and not the Constitutional Court. That was an explicit decision. I would say surely because the Constitutional Court lacked sufficient legitimacy, political legitimacy. So it is the Supreme Court that will control the formal limit of 2/3. there's a debate about the possibility of having the Constitutional Court controlling some material limits written in the Constitution concerning treaties. Mila mentioned international law, treaties, the Republican form of government, the effects of judicial decisions. Now, let us, if you want, turn on to the future of judicial review, given the fact that our Constitutional Court has this legitimacy problem. What do you think should be, or might be, or could be the decision to be taken by this Constitutional Convention concerning judicial review? From the way you look at the comparative scenario, what might be in a formula that talks well with our experience, our reality, and the problems judicial review is having all over? I know it's a very broad question, but I will be very glad if you commented on this. And the order now, it's Mila first, then Andras, and finally Tom. So judicial review in a new constitution in 2021, Tilly.
Okay, so thank you. So I'm not sure if I have that much to say about this, but other than that, I don't think there is a single formula. Maybe I'm repeating myself at this point, but I do think it's important to realize that we expect a lot of constitutional courts, right? There's these many roles that they have to play. They have to enforce the Constitution, right? Make sure that the rules written in the Constitution are adhered to. They also have to enforce international law, right? In most countries, that's part of, especially in monist systems like Chile, right? It's one of the roles is also to enforce international treaties in the domestic legal order, and that creates its whole own set of tensions, right? What if international law maybe conflicts with the Constitution? Which of the two prevails? So there is that whole set of questions to sort out. We also want courts to enforce democracy, right? What if there is abusive, undemocratic practices? We want courts to play a role there. They have to safeguard the Constitution, even against constitutional change, for example. We want courts to be somewhat responsive to popular opinion, while at the same time be counter-majoritarian when popularly enacted legislation contradicts the Constitution. So there's these many, many roles that constitutional courts potentially play. And I think ultimately a constitutional court for Chile would have to chart its own course, right? Mindful of all these different tensions that are built into this, all these many roles that it has to play within the system. So I think, I guess that's the main thing I have to say about it. And then the other thing, I think we sometimes put too much emphasis on court when it comes to the success of constitutions, right? I personally believe, based on anecdotal observation, I guess, and some research that I've done, that ultimately what matters the most for making a constitution work is that ordinary people and groups within society actually are committed to the document, and their actions can be more important than a court alone, right? Courts and social movements can be mutually reinforcing, but it's really hard for courts alone to do all the hard work of making a constitution come alive and actually matter in a country, right? You need much, much more than that. You need people behind the constitution. You need dedicated citizens, and you need the government officials to be committed to the document, right? So I think we sometimes focus too much on courts when we think about the success of a constitution, especially among legal scholars and lawyers.
Thank you very much, Mila. Andras, please.
Thank you. Just a few thoughts about how to decide whether certain competencies should be given to the Constitutional Court or to a Superimport, to the ordinary court system. I think it has always been decided in constitutional history the very pragmatic considerations. So after the Second World War, in Germany, they have set up a new constitutional court, which was separate from the ordinary court system, because the ordinary court system was full of Nazis or National Socialists. And in Eastern Europe, after the end of socialism, most countries set up a new constitutional court separate from the ordinary court system, because the old ordinary court system was full of communists. So if you want to have a social change, or if you want to put a certain agenda, you have to consider, the situation, what kind of people are sitting in one institution and what kind of people in the other. It is possibly very shameless to say that, because constitutional lawyers don't like to talk about it, but I think this is always how it happens. So it's like practical or pragmatic considerations. If you don't trust the old constitution or the constitutional court because certain type of people with certain political affiliations or past are sitting there, then don't give too much power to them. If you trust them, then you should give the power to them in a number of cases. I agree with Mila that for a long time in the literature, too much emphasis was given to the role of courts in upholding the Constitution. I also think that to a much larger extent, it's ordinary citizens or possibly like political actors. I would maybe emphasize that, like political parties or political groups are important in upholding. So when we look at the relationship of, the rule of law and democracy, for a long time we considered it. I think that the rule of law was some kind of guardian of democracy. So the rule of law and courts were guarding democracy. But as a matter of fact, it also works the other way around. So you need the democratic process to work properly, and then independent courts will be able to act. So it's kind of a mutual dependency. Or sometimes I also like to say that it's like a good marriage, where you have certain structural conflicts, but at the end of the day, you need the other one to be happy or to flourish. It was very poetic. Sorry about that.
Thank you very much for that romantic and hopeful view on marriage, which I share, by the way. Please, Tom.
My wife's not here, so I'm not going to have to say anything here. So look, the question of how to design judicial review, as Mila mentioned before, we showed that it's something like 75% of countries have some provision for constitutional review. And nowadays, constitutional courts have become, the most popular option. But I actually observe, I haven't written this up yet, but maybe a small trend, maybe away from constitutional courts in some of the discussions I follow around the world. And that's because of two things. First of all, whenever you have a special constitutional court, you have these complicated problems of jurisdiction between the Constitutional Court and Supreme Court. And we know many countries where those conflicts have really become quite serious. Chile, maybe not so much, but those can be a big deal. The other thing is that if you think about the backsliding question that we were asking before, it's much easier to take over a constitutional court than a Supreme Court. And that's why we saw in András's home country and in many others, the first thing the backsliders do is take over the constitutional court. It's fairly easy. And that obviously can be the critical moment, because then everything else they do is constitutional. To take over ordinary courts, you have to have law schools and work the judges up through many generations of climbing from the bottom to the top. And it's not so easy, but of course it can be done too. So, it's all about, constitutional design is all about competing risks. And oftentimes we're very much focused on yesterday's problem. András mentioned, that we created constitutional courts in the post-war period because people were afraid that the ordinary judges were, had tainted pasts and stuff. But I think this is a moment when Chile should be thinking sort of fresh. You know, you don't have major problems. Obviously, these institutions have reputations, but I wouldn't let yesterday's reputation guide the design decision. That's maybe all I'll say. I want to be very general in responding to this question.
Thank you very much. And so before we start the last round of questions, I would like to encourage our public to make questions, and we will see if we will have time at the end of the session to maybe select one or two, depending how much time we are going to have. Entonces, por favor, si tienen preguntas, estaríamos más que felices seleccionar una o dos, dependiendo de cuánto tiempo nos queda. Y también pueden usar para eso la función chat. So the last question is actually, again, we are going around, obviously, from a certain perspective, the same core issues. And the last question is about rights. And many of us, like all of you, actually have already made some references to this issue. And I would say that the first or the second question, which was about rule of law, has to do a lot with rights and the efficiency of rights. And also, I think Tom was the one who made this reference that one of the big challenges today is that the system, like in Chile at least, or actually I would say most of in Latin America, that the system is kind of like contra law, and then you corrected yourself and you said that it's contra the political system as such. But I would say that there is something, at least a partial true in the first version that you mentioned, that there is something that is diminishing about law as such. And so I think that this question about the efficiency of rights has to do a lot with this, not just because in the new Constitution of Chile, rights, human rights, and economic rights are going to be one of the biggest issues, but also that there is a logic of rights that, depending on what type of constitutional theory you're applying, and then here I'm referring to Undie and transformative constitutionalism, and all those have a lot to think about. So if you don't oppose, I would apply the same order of answers, and we can start with Mila, please.
Okay, thank you. So the question, how do we actually make rights real, is of course a difficult one. It's one that I've done some research. I actually just wrote a book trying to answer the question and feeling unsatisfied about the whole enterprise because it's not an easy question. But let me say a few things. First of all, writing a right in the Constitution doesn't necessarily do very much, right? Just putting a right on paper doesn't mean that it actually will be implemented in practice and actually change anything real that we care about when writing this Constitution, right? So that's a first insight. Second, for rights to actually do make a difference and to become, actually have a transformative impact, what you really need is power behind the rights. And by that, I mean organized groups of citizens that are willing to put money, time, effort into enforcing the right when necessary, right? So in the book that I just wrote, one of the insight is religious groups, for example, and their freedom of religion. That turns out to be a good combination for actually making a right work, right? If you have freedom of religion in the Constitution, religious groups are well organized, they're well funded, they're very motivated, they have members they can call upon to mobilize, so and they are increasingly smart and savvy about using the Constitution. So freedom of religion is a right that you actually see is associated with better practices in many countries, in large part due to the effort of organized religion, right? Whatever religion that may be. And that is harder to emulate for other rights. Like, for example, the freedom of expression, right? Who are the people that really care about this? I mean, we all care to some extent, but there's no group that really owns the right, like you have with, like you see with religious freedom. Another example of a right where you have power behind it to some extent is the right to unionize, right? Turns out trade unions are well positioned in many countries, even though they've weakened over time to do the hard work of enforcing a right. So I think the challenge is to create or to have these dedicated groups that care about these rights enforcement, right? So, and one of the things we found is that even in not so democratic settings, religious groups may be successful because they're so well organized. For rights where there is no natural constituencies, like religious groups for the freedom of religion, it may depend, right? You really need social movements behind the right that are mobilized and organized, right? So and I guess earlier I said, oh, it's important that citizens care. Yes, it's important that citizens care, but ordinary citizens are usually not organized, right? And so we often talk about, oh, social media and its potential to call out rights violations, for example. But I also found in my research that that's limited to some extent, because often social media movements, they last a moment and then they're gone, and nobody actually knew who was behind the movement or what the movement was about in the first place, right? So actually making rights real requires formal organizations that have leaders and that have members and that have a plan, right? Which you don't always see for social media movements. So first, writing a right in the Constitution per se doesn't necessarily matter. Second, when you have organized constituencies behind a right, then maybe they do matter. And third, I guess I do want to mention this again, that more rights is not always better, right? More, maybe less, because think about it this way, right? What the Constitution does is it declares some value to be higher law, right? And we can say once a government crosses this line, it really goes a step too far. Now we're going to mobilize. Now we can go to the Supreme Court or Constitutional Court. Now that these laws can be struck down. But once all good things under the sun become a higher value, you basically have no higher values anymore. And I think it's a point worth emphasizing, right? Because you constantly have conflicting values. If all good values are higher values, then how do you pick between 2 or 3 or 4 or 5, 6 competing values at stake within any given policy decision, right? You haven't made anything constitutional law anymore. So then what happens is it becomes much easier for politicians to say, well, we were not, there is competing values here. There's gender equality, there's religious freedom, there is indigenous group rights, there's economic inequality. They're all at stake here. We are picking one of them. Right, you're basically unbinding constraints from those who are making decisions, or you're giving the power to the court to make these decisions, right? So it'll be every right has to be balanced against each other. So either you're delegating an enormous amount of power to the courts, or alternatively, you're just giving power to an executive, or both, right? So I think that's worth emphasizing, that more is not always more because of the logic of how constitutional law works. And then finally, I think it's also worth thinking about, and I'm sorry if I'm going on long, but like for what kind of questions are rights well suited to potentially solve, right? So there is this argument, I mean, to some extent associated, for example, with Samuel Moyn's work, is that if you want to address economic inequality, right, like going to social and economic rights is kind of a pathetic solution to the problem, right? You need much bigger, you need stronger trade unions, you need reforms of antitrust law, you need to restructure your economy, right? Can rights do this work? Maybe to some extent, but it's going to go through the court. It's going to go one case at a time. It's not going to, it's in some ways, it's a very conservative way of dealing with economic inequality. There are much more radical ways of dealing with economic inequality than writing social rights in your constitution. And I don't want to take a position there. I'm not an economist, but I do want to make that observation.
Thank you very much. Yes, this question was, besides being very relevant and very actual here, it was obviously suited to all of your research agendas and books. So yes, the next one I would like to give the word to András.
Thank you. I think what we're talking about here are always just probabilities, and they are very important, but as also Mila mentioned, it's more about probability. So when it is more likely that the human right will be enforced in practice. So I think when you qualify something as a human right, that in my view it has three functions, or it's important from three point of views. On the one hand, it's a rhetorical tool, so you can name what is really important in that political community. So it's not just something which is mentioned as a, I don't know, like a goal for the state, something to achieve, but it's human right. It's more important. So it's a rhetorical tool, which I don't mean that in a pejorative sense. That can be important, what you emphasize in the political discourse, and the consequence can be that you qualify it legally as a human right. The second can be it's very technical. So if you qualify something as a right, as a subjective right, then it can have an influence on who has standing, like local standing in a court. So in a very technical procedural sense, it can have relevance. And number three, it can, in the legal reasoning or the constitutional reasoning, it can give a bigger weight to that value which you conceptualize as a human right, because then it's more difficult to limit. You need normally a proportionality test, depending on the legal system. In some constitutional systems, doctrinally are not that sophisticated, and they don't really make this difference. But in quite a few constitutional systems, you have a difference what kind of test you apply, proportionality test or some kind of necessity test, and it can depend on how you qualify or what you qualify that value, whether you qualify it as a human right or not. I think when you put something into the Constitution, it's like in a theater. So when in the first scene somebody is putting a gun on the wall, then you expect that sooner or later somebody later in the theater piece will use that gun. Maybe it's not going to happen, but there is a certain expectation that if you put something into the Constitution, it might be used later. There is no certainty, obviously. It's just like talking about probabilities or possibilities. So again, it's boring for me to say I agree with Mila. I mean, she wrote a great book about it, but mentioning human rights is not totally ineffective, but simply by mentioning them, it has limited effectivity. You also need other factors, but at least the possibility of their use is there once you have it in the Constitution. So it's not the solution, but it's a kind of a limited help if you want to emphasize something in a political community. Thanks.
Thank you very much, András. Please, Tom, the floor is yours.
Yeah, I'll be very quick, but just to make things interesting, I think I'm going to disagree with my colleagues. So traditionally, I had the view which they set out, well, we should be careful with these rights. We have to make sure they're implemented. But we're at a moment where the demand for rights is coming from outside law. It's a genuine demand that we deal with certain things. And I don't think it can be stopped, and particularly not in a context like Chile right now. So then the question is, how do you channel that energy into something that's workable? And I am quite sympathetic with some of the literature. Johanna actually mentioned privately Jamal Green's new book. We should use a more proportionality-based approach to balance things. And I think that's all fine. One thing I think would be good for the Chileans to consider is the use of directive principles for many of these things. So let's take the rights of nature. Big trend. maybe a good one, because everywhere around us we see that nature's interests aren't being protected in any sphere, and proportionality analysis might be useful for sort of saying, well, we have these, interests that should be brought into the balance. Now, I'm not saying whether or not Chile should adopt a right to nature, but I do think there would be no harm at all from saying that there's a directive principle that state policy should be directed towards environmental protection and taking in the interests of future generations into account. What's a directive principle for those students who may not have heard of it? It's basically a statement that this thing is in the Constitution. It's not justiciable in courts. It can't be raised in a court. But it could be something by which we hold the legislature and the government accountable. So you could imagine an annual report where the legislature had to say, well, what have we done to meet these various directive principles? And that brings it back into the political sphere, I think. And so I think things like that should be considered. And I don't think we're going to be able to stop a lot of demands for rights, some of which in the Chilean context are good and pretty easy to meet, like indigenous rights and things like this.
Thank you very much. Well, I would say that I would agree with András if I knew that it would work here, but my impression is that it's as Tom said, that it would be kind of unpresentable to be choose like a self-constraining approach on rights at the very moment. I don't know if any of you would like to make a comment or answer or react to.
I can say something. I think Tom is right, which is not a great thing to say after he said he disagreed with me. But I do think he is right that there are tools available to both deal with the demand for rights and solving some of the problems I raised, right? So making some rights, making them non-justiciable. So they're there, they serve the important symbolic function. They can be used by social movements and such to hold legislature accountable, but you do solve the problem of all these values always coming into play when you have, when any decision comes up. And I of course, I also am sympathetic to Jamal's Green's suggestion that we need more balancing of rights. Like the American approach is often mentioned as an extreme example. Well, we just picked a few rights and those are the ones who always win out, right? Whereas other countries write more rights in the Constitution. But I think you can also go too far. And once everything is a right, you just have these legal problems that proportionality may not be able to solve anymore. But I do think some of the constitutional design solutions that Tom raised of creating tiers of rights or sort of or hierarchies within the document, I think could be a really useful thing to consider.
Thank you very much, Mila. Any other comments or reactions? Perhaps if. Okay, so we have really just a few more minutes left. As far as I can see, we received 2 questions. Perhaps we can choose one. I don't know if you are, if you would have time for that, and perhaps it could function as a volunteering basis. So if any of you would like to answer that. So the question, the one I would prefer choosing is related to the work of the Constitutional Convention. That is going to have an exit referendum at the end of its work, where the referendum or through the referendum, the people can approve or reject the new constitution. So the question is, do you think this measure will affect the work of the convention as a ghost thought? And moreover, the future of constitutional law in the eyes of the Chilean public, especially if the referendum ends up rejecting the new constitution, and in brackets, although I doubt it will come to that. This was made by the author of the question. So I don't know if any of you would like to volunteer for the chances and impact of an exit referendum of the Constitution and how that would influence the work of the Convention.
I can say something very briefly, which is this is what Professor Jan Elster, who very famous professor of constitutional law, calls a downstream constraint. So all the negotiations in the convention will be thinking about this ultimate referendum. And it's good because, you know, ultimately the people have to live under it, and you do want some constraint. And so then the question becomes, what are those constraints and how do those conventioneers, convention people, read the public? And here, what I mentioned at the very beginning, the outcome of the election for the convention was very interesting because, as I said, we're electing many independents to do this job, but we're still electing many traditional parties to do the governance job at local government level. So maybe that will be the perfect combination, that the conventioneers will be responsive to the need for change, but not completely radical in a way that the public would ultimately reject. So I think somehow my prediction is that Chile has managed to take all that energy of the social protest and channel it into a constitution-making process that turns out to be pretty well designed, and we'll see. It seems like some good chance of getting to the other side of the bridge, as you mentioned, getting through that referendum. That's my comment.
Thank you very much. So I think here we can call an not a night, but call an end to this session, to this event, which I think was utterly interesting, and in order to guarantee a broader diffusion of your knowledge and of the answers that you gave, we are going to make a transcription of this conversation, and we are going to translate it to Spanish, and we are going to upload it to the webpage of the Foro or the webpage of the university. So thank you very much for all of you, for the public, for our great panelists, and for everyone who has accompanied us. Thank you very much. See you soon, and please, Patricio, if you would like to give some final words.
I want to insist on the thanks on behalf of the Catholic University. Our three great friends have had enthusiasm, goodwill in tackling complex questions in 5 minutes, 6 minutes, 7 minutes each. So I'm really thankful and thrilled, and I want to stay on the final words of Tom Ginsberg. Pretty well designed. I think it's a good design. Now it is our responsibility to live up to it, to make it count. And your help in giving us your opinion, your comments, your knowledge is welcomed, highly welcomed. I'm not speaking for Chile. I don't have a right to speak for Chile. I was given that message a month ago, not being elected, so I can't speak for Chile, but I speak for the community of constitutional lawyers and professors and our university. Thanking you very much for having this interest and this sympathy for our process and the good tips you've given us. So thank you very much. Thank you, Alejandra, for the space the Foro Constitucional gave us. Sebastián, the director of our Sebastián Soto for Constitutional Law Department, and to everyone for being with us this afternoon. Thank you, Joanna, for organizing this.
Thank you. Have a good night. Have a good afternoon.